Good Saturday morning to you. Welcome to Legal Notes Radio Show with Mary Ann Charron and Ned Barron, elder law attorneys. I'm Gary Byron. How are you guys this morning?
Well, it's early, Gary. But
I know it's
doing great.
It's a little. See, welcome to my world. This is nothing for me. This is 7 o'clock hour on a Saturday may be different. Monday through Friday, I'm up at 4 o'clock in the morning. Our producer Ryan, he knows what it's like. This is how the other half lives. So you got, we actually, you may remember that last week, Mary Ann and I discussed powers of attorney. Now, this morning, we are going to be discussing what happens if you don't have power of attorney documents. But first, let's go to the mailbag. Yes, indeed. We received our very first email for Legal Notes. All right. It is from Larry in Avon, who sent in a question based on our conversation about living wills. He writes, isn't a living will the same as a DNR? If not, could you please explain the difference? Well, okay. I don't know what a DNR is, but I suppose he does, obviously. I would presume you two know it as well.
Yeah, we do. I was so excited to get the email. So
your first one, yeah.
Yeah. So a living will and a DNR are actually two separate documents. Living wills we create, we draft them for people, and DNRs, it means do not resuscitate. Oh, that's what a DNR is. And doctors, you get them from your doctor. So that's the thing you can wear like as a bracelet. Some people have it as a chain, and what that means is that it's for your healthcare providers to know that you do not wish to have certain treatments, and so you're not to resuscitate them. A living will, however, I don't know if you remember, but a living will is you have to be on death's door. So you have to have no behavioral response. You have to be permanently unconscious. You have to be in a persistent vegetative state. The doctor has to say you're dying, and then we can choose to not hook you up to life support. So they're really, one's on one end of the spectrum, and the other one is on the other.
That's when you would be dying just naturally, then, right? I don't want to say pulling the plug, but I mean,
if you assume that the plug is what keeps you going artificially, then yes, you are asking to be allowed to go naturally, right? So as opposed to being continued to be supported.
Gotcha.
But a DNR is a different document, and we do not draft them. Gotcha.
Okay, so do not resuscitate. Mm-hmm. That's a bracelet that...
You don't want to wear?
No. No, I mean, if I'm stranded on the side of the road, I've been hit by a car or whatever like that, and I'm, resuscitate. If you can save my life, how could there even be a question? No, I mean, save my life, my goodness. Mm-hmm. But I get if you're in a vegetative state. Yeah, I mean, there's pride associated with that. I don't want to be remembered for, I'm alive, my heart's beating, but I'm not alive, right?
Well, the DNR would... The setting being on the side of the road, that would not be typical. Typical would be if you were in a nursing home or you were in a hospital setting. So you're being cared for. The bracelet is to let your caregivers know that you have chosen to, if you do choose that, to have a DNR. So it's typically, as Marianne said, it's drafted by the physician, and it's a document that the physician actually presents to their patient. When the patient is, typically it would be someone who is elderly in a nursing home who is at the kind of later stages of their lives. And to resuscitate would just prolong maybe not a very high quality life that they're having already.
That makes sense.
So, so the interesting part about it is that, in that, let's say, nursing home setting, that not everybody has a DNR because it is a voluntary choice. And so, again, it's something that is discussed between a physician and their patient as to whether they want that. If that patient doesn't have the capacity, then somebody who does have the authority, such as their healthcare agent or a conservator of person, could be the person to make that determination as to whether or not that DNR should be in place.
Okay.
But once it is in place, then it alerts the nurses, other doctors, or EMS. When EMS comes, they're often looking either for a bracelet or in a nursing home, like on the back of the door, they'll have a packet of information that has the DNR, and it lets them know no chest compressions, no defibrillator, don't take any efforts to resuscitate me if I have had a heart attack or I've passed away, because I don't want to be resuscitated.
Interesting. So you don't need both.
Well, they do different things.
Or do you?
They do different things. So imagine you're talking about yourself, you're on that side of the road, right? Mm-hmm. Your family members have the living will, and they EMS, which are the emergency medical, okay? They ambulance you to the hospital, okay? And they have to save your life. They're starting to resuscitate you. They're starting to provide you with fluids. They're starting to provide you with nutrition, hydration. They give you a PEC tube, right, to keep you alive because they found you in your example on the side of the road. So severely injured, we'll say. Let's just add to that. So what happens is that your family member, your spouse or whatever, comes in with a living will. A doctor says, look, we're doing everything we possibly can for Gary, but he's not going to make it. Look at the brain waves. There's no brain waves here. And if you have the living will, which is different than the do not resuscitate, because if you had a DNR, they wouldn't be doing all those things to you.
I got you.
Okay?
Yep.
And the living will says, do we want to continue to keep Gary hooked up to that life support? And your wife goes, not yet. Not ready to let him go. No.
Well, no, but that's a
right?
that's a tough decision. Yeah, you're right. I'll bet that happens all the time. Mm-hmm. But yet you've got to follow what that person wanted, what that individual wanted.
Correct.
It's not so much what the spouse would like.
Right.
To your example, I'm not ready to let him go or her go.
or do it now. No. I've been waiting for this day. No.
It's about time. Finally, the strychnine worked.
But that's right. But either of those circumstances, that's right. I mean, obviously you're young. And we try to understand that, because when we're young, we expect people to bounce back, right? Your body might be in a state of shock, but we're going to wait a longer period of time before we pull any life support from you. Well, but if we're older, if you're in your 70s, 80s, let's say, or even older, just performing CPR could kill you, right? Breaking ribs could kill somebody who's older and whose bone structure is much more fragile. But for you, Gary, we would do CPR.
Well, thank you. Though, it's very interesting. I've actually had this conversation with people regarding how you age and your body becomes more brittle, and performing the Heimlich maneuver. I've always thought that, geez, there's this little old lady. I remember working when I was in my early 20s. I worked at a psychiatric institution. I worked in nursing. As what I think they call him a resident counselor, but nowadays, but back in the 80s, it was a psychiatric technician, a psych tech was what the title was. And I worked on a unit, and I remember filling in the geriatric unit one day. And of course, I'm certified in CPR and life saving and Heimlich and all of that. So, and I remember seeing this very frail, old. When I say old, she's got to be, must have been in her late 80s or early 90s even. And I thought to myself, I can't imagine ever doing a Heimlich if she was ever choking on something without breaking her bone. So that's so interesting. The interesting thing you said, when you said that, that's the first thing that came to my mind. Mm-hmm. What happens when you don't have powers of attorney in place? So
when we talk about powers of attorney, we're talking about generally about a financial power of attorney or a medical power of attorney, which oftentimes we call it. It's an appointment of a healthcare representative. But in Connecticut, if you become incapacitated, because those documents are going to be used for incapacity, if their documents are not in place and a person is unable to make decisions for themselves, whether it's financial or medical decisions, then somebody needs to get that authority. And in Connecticut, we have a statutory provision called regarding conservatorships, or some people call it conservatorships. And when I speak about it, I might use both terms, both pronunciations. But it is a process that you go through with the probate court to have someone, well, first of all, to have the person found to be incapable of making decisions for themselves. That would be
that's got to be determined first,
okay. Right? Well, for an involuntary, so the probate court has to make that determination, but the process does go through the probate court.
So how about if we take your example? You're still on the side of the road.
Okay.
And you have no power of attorney documents, right? Mm-hmm. So now who is going to be dealing with the doctors and the hospital and authorizing whatever has to be done for you or not done, right? Who is it going to be?
I would imagine.
So if you don't have, we always assume that our family can do it, but because of HIPAA regulations and everything else, you actually need somebody who is authorized to act on your behalf. So there you are, you're at the hospital, we don't have anybody. Now, they are providing life support to you because that's what doctors are supposed to do. Mm-hmm. But then, who's going to authorize the surgery? Who's going to, authorize a course of treatment for you? If you don't have a power of attorney document, in this case, in the example that we talked about with you, that's a healthcare power of attorney. And if you don't have it, then you have to go to probate court. And that's what Ned was talking about. You end up in probate court, and someone has to apply to become your conservator of person.
Okay. And
that's what, maybe that makes a little bit more sense when we use your hypothetical.
Wow. So,
right? So you have to go into probate court, and there's an application, and there is a fee. Not that it's not significant, but there is a fee, and you have to have a hearing. And Ned was talking about he mentioned just briefly, there essentially are two types of conservatorships. If you want to go into further detail.
Sure. I just want to touch on the fee aspect. There is a waiver program in place. So if you qualify for it financially, then those fees are waived.
Okay.
Right now it's $250 plus a marshal fee.
And how would you qualify for that? If you're a low income family, or
yes,
okay,
yep,
yeah. If you're on Medicaid, you automatically qualify for it.
Okay.
But
you still have to fill out the paperwork to meet their requirements to be eliminated from.
Yep.
Okay. Right. So as Marianne was saying, that there are two types of conservatorships. There's a conservator person, which Marianne already talked about, which deals with medical decision making. Also, where does this person live? Those types of decisions. And then the other one is conservator of estate, and that is regarding financial decision making. So that person who was appointed as conservator of estate would receive the income of the person who was conserved. They would pay their bills. They would make sure that if they were on, let's say, Medicaid, or they would make sure that those programs the redeterminations are done or applications are made. So they really handle all the financial aspects of that conserved person's life.
Oh.
Right. So if we take that example again, you're injured on the side of the road, hospital. So all those hospital bills coming in.
Yeah.
Who's going to pay them? So you can't just contact so let's say you have a savings account. Let's say you have a 401k. Let's say you have an investment account, right? That's just in your name. No one's going to be able to use that money to pay your bills unless they have some authority.
Is the person who's making those decisions, the financial decisions, the one paying the bills, the example that you just gave, mm-hmm. is that the same person as the one who makes a decision medically?
You want to take that one? I mean, it can be.
Yeah, not necessarily.
Okay.
But not necessarily.
They are two distinct roles, but I would say generally that the court will appoint the same person to be the conservator of person and conservator of estate, but it doesn't have to be. The court doesn't have to do that. It really depends on the situation.
What would occur if there are siblings, if the
mm-hmm.
individual has more than one child? And I mean, it depends on how much we're going to get into the weeds here about religious beliefs or philosophical beliefs. And there is a power struggle between the siblings that I'm sure this poor person who is dying, for all intents and purposes, probably would not be too thrilled to be aware of. I suppose this goes right back to the more preparation that you do, the more pre-planning that you do, the better off. If you're crystal clear, and I get it, it's very difficult to have this kind of decision. You don't exactly, at Thanksgiving dinner, you don't exactly, bring this up. By the way, folks, when it's my time, it's, geez, Dad,
not today.
Today's not the best day. Yeah, but sometimes that's the only time you get families together.
Absolutely.
If somebody's living out of state and they're coming in, hey, happy Thanksgiving, everybody. When? Yeah. You don't want to have this over email, right? I mean, but what happens? You must have come across just by your experience where you have children of this individual who have completely either religious or philosophical differences than what was originally wished, or a power struggle between siblings.
Yeah, it happens. You want to go? We certainly have enough cases where both Ned and I have.
I would imagine that's probably right up on the top of your list of experience.
Mom loves me more. I know Mom better.
But it's not even. Okay. So there's that. But forget that, though. Let's say that they love the children equally, and they were both showered with affection and love and everything. Yeah. I'm talking about philosophies that were created in adulthood. Yeah. After that whole Mama loved me more or Daddy loved me more, where, no, we can't do this. Right now, before the legislature in Connecticut, there's a death and dying bill. And I remember when I was in the legislature for my 2 terms, oh my good! I didn't even sit on that committee, and I was hearing from constituents. I'm like, I don't have a committee vote because I don't sit on that committee. But if it comes before the entire legislature, yes, I will then have a vote, and let me take your philosophy, your opinion of this, into consideration when we get to that. And interestingly, the bill died. No pun intended. But now this year it's before the legislature again. Well, now that all aside, I want you to. You know where I'm getting at. What happens when you've got conflict?
Yeah.
Sure. Well, when you have conflict, the easiest thing to do, so if you have 2 siblings and the 2 siblings each want to take on that role, that there is possible for the court to appoint both as co-conservators.
Okay.
However, if there's that much animosity, if there's that much disagreement between the 2 of them, that's probably going to become very apparent in the court, right, during the hearing. And the judge would probably be unlikely to appoint either of them.
Yeah.
And the court could appoint an independent person. And quite often courts do appoint independent persons. And Marianne and I both have acted as conservators because the probate court, the first...
To clients or members of your own family?
No, to people who we don't even know.
Okay.
The probate court has appointed one of us to act in that role.
Okay.
Mm-hmm.
So the statutes provide, and the courts do appoint, and traditionally it has been attorneys who were appointed to be conservators because of attorneys' expertise in the law and with dealing with helping clients with their medical issues and with financial
Medicaid and Title 19 and other types of entitlement programs when people become long-term care, need long-term skilled care. It's very expensive, and so you have to spend their money in order to qualify them for those programs, and it's complicated and it can be incredibly overwhelming for family. And so Ned and I both have been asked at times by probate court judges to take on those roles. So
would one sibling then say, well, you're siding with the other one? Absolutely. And kind of pit you one against the other? And you're like, listen, I've got no dog in this fight. Mm-hmm. I don't know either one of you any better than the other one. Yeah. My client is your, mom or dad.
Correct.
Here, and I'm looking out for that person's best interest. So however this cookie crumbles is wherever it crumbles. It doesn't mean I favor you any more than the other, your sibling.
No. So either this child could ask for a hearing in probate court to say, I think what Ned is doing is wrong. Or Ned could ask for a hearing. It's called a motion for advice. And would say, hey, we have this issue. This is where I'm going with this. This is the reasons why. And you have an opportunity in court to let everyone have a voice. Ultimately, I think what's interesting, I know we haven't had much chance to talk about it yet, but when you're a conservator, you are acting as an extension of the probate court judge. You are literally their hand. They are someone who, because you're acting as the judge, you're acting as the probate court to be able to handle this for an individual. I mean, let's face it, you're spending their money and you're making their life decisions for them, life or death decisions for them, right? So we have had animated conversations with siblings. We've had very animated hearings, and ultimately the judge either agrees or disagrees with us, or agrees or disagrees with the children, and you move on for the benefit of the parent.
That's a thankless position to be in, because you're loved and hated at the same time.
That's why they pick us. No.
Oh man, folks,
It's not easy.
You're listening to Legal Notes radio show. Mary Ann Charron and Ned Barron, elder attorneys. I'm Gary Byron. No, but seriously, I'm just listening very intently to both of you, and wow. I mean, that's a tough. Look, I know you're trained and you're attorneys, but that still
tough.
doesn't strip away the. No. You really have to massage your way in there perfectly and articulate in your communication to the sibling who thinks that they're not being considered or their opinions aren't being factored in any of these decision making. So you mentioned again there are two types of conservatorships.
Go ahead.
Yeah. Right. Well, we talked about that there's conservator person and conservator of estate. One of the things, the distinctions that we want to make today is that within those can be either involuntary or voluntary. The difference being that with a voluntary conservatorship, that it's the person seeking the assistance, right? Let's say it's the elderly person who is not being able to take care of their finances as well as they used to, or needs help with medical decision making and all that, they can actually petition the court to ask the court to appoint someone voluntarily. So they're saying, court, please appoint somebody to assist me with these decision making issues. And so the difference is in that is that there is no finding of incapacity, and that if the individual wants to terminate that conservatorship, they finally say, you know what, I don't need this anymore. They just send a letter to the court, and the court has so there's a time frame, 30 days after that letter is received by the court, the conservatorship is automatically terminated. So, but it is a nice way for people to be able to get help, some support. Oftentimes it's by someone that they don't know, because if they had a family member that they could turn to, then they would seek help from them. But it's a nice process to have in place to help people.
And you're talking more about court procedures, or what are some of the court procedures? I know there's a voluntary, right?
So Ned was just talking about the voluntary one, where you go into court.
Okay.
And then there's the involuntary, where a person doesn't have capacity or is in a hospital and has in a coma, for example. That's an easy one.
Yeah.
And you have to file an application with the probate court. But in that one, as Ned was saying, the court has to determine that you lack capacity. So we have all of these constitutional protections in place because we are depriving you of your right to make a good decision, but your right to make whatever decision you want to. So a physician has to say that you are incapable. So a physician's evaluation is necessary. And there's a trial, there's a hearing on it. And our courts do require that you as the individual get a court-appointed attorney because you have rights that need to be protected. So it's significantly different than a voluntary procedure.
Mainly cognitive? Is this when a person isn't mentally capacitated? Or
Yeah. I mean, sometimes there are physical incapacities.
Oh, sure.
Right?
Yeah.
But yes, certainly it addresses cognitive incapability. That's right. So your decision-making is compromised. And the people oftentimes don't realize it. Like when you're older and you're holding on to whatever you got, you want to make your decisions. You want to be able to say,
oh, absolutely. So is this permanent or?
Well, that's a really good question. And the answer is no, it's not permanent. You want to talk about that? Yeah.
Well, sure. As I already explained regarding the voluntary, that the person who is the subject of the voluntary conservatorship can terminate it by sending a letter to the court. However, if you're involuntarily conserved, that the way to reverse that, to terminate that conservatorship, is to prove to the court that you have been restored, that you are no longer incapable. So there's an application process to the probate court, and there will be a hearing. Yeah. And at that hearing, evidence would need to be presented to show that you are now capable of making your own decisions.
But you're at least provided that opportunity.
Absolutely. Yeah.
And how? When would you? Is it every 6 months? Would you be provided? Let's say you got denied. If you got denied,
you can come back
for the application. You can reapply. And is there a certain amount of time that you have to wait? Oh, okay.
No. I think the rule of thumb is 6 months.
You want to, unless there's a change of evidence. Something happened, right? So you have new meds and you're clear, or whatever the circumstance. If you are no longer in that coma. And you know what I mean? Or the accident. So, but you want to wait because the judge is going to be like, okay, Marianne, what's new now?
Yeah, what's different when you're here 6 months ago? Folks, right. You have been listening to Legal Notes Radio Show, Mary Ann Charron and Ned Barron, elder attorneys. This is such an important show. I think you're opening up a lot of people's eyes just listening to you. Opening up my eyes. Not that I ever thought I knew a lot about this, but turns out that there's more that I think we all would benefit from. Check them out online. Their website is www.charteroaklaw.com. Once again, charteroaklaw.com. And of course, and that's why I tell people always start there. Start on the website, because you may have questions right now. And when you go online and you go on their website, A, you may find the answer right there. Or two, it might provoke and spark other questions for when you give them a call. You could ask all your questions at once. 860-570-1229. Once again, 860-570-1229. That's for how you can get in touch with both Marianne and Ned. If you'd like to have your question answered on these very airwaves, hey, who knows? Could even be as soon as next week. Very easy to do. Simply email the show, legalnotes@charteroaklaw.com. It's that easy. legalnotes@charteroaklaw.com. Hey, like I said, who knows? Maybe as soon as next week. For Mary Ann Charron and Ned Barron, I'm Gary Byron. Thank you so much for listening to Legal Notes. We'll talk to you next Saturday, 7 a.m. Until then, have a good one, everybody. So long.